Okay, so regarding to setting out, also this is another component here. So the contractors are responsible for setting out of the job. Okay, and it will include all the grades, responsible benchmarks, all the levels and all that. So they must check, you have to set up the work according to the TOEFL or according to the survey plan. In many of these, they will say get a professional surveyor to do the job. So you must ensure their tax, there's marking, there's reference points all set up properly. So this is very critical, and usually, like I said, they will call for registered surveyors as well. If there's any error discovered after you've done the job, anything that is dismantling, that is out, we hope, the contractor has to pay the loss, because setting up is the job of the contractor. Okay. Information are provided by client in some sense, some cases, but again, with the other close, a pre-site visit, you have to actually check yourself. That is what the client is saying to everybody. Okay, so then the last thing here is on instructions. Okay. So instructions are very fundamental. So I think a lot of these things, if it's not very specifically, mentioned or say in the clauses, it will be covered under this category of instructions. So SO or supervisor, architect or whatever under the contract, you are delegated to actually give instructions. You have the right to give instructions. Okay, but instruction on certain things, okay, not on everything. So we'll come back to that as well later on. Okay, so instructions may be, due to word sequence, it can be methods, it can be coordination, it can be compliance with design, like I said, asking contractor to furnish work method statement, asking contractor to furnish P2P, asking contractor to furnish a timeline, schedule, working program, and asking contractor to furnish evidences for EOT, for loss and expenses. So these are all broadly under those additional relevant documents, and this is like instructions for requests for these additional documents in that sense. Then there will be also instructions, especially very important when that is dealing with variation. I don't want to talk too much about variation here, because I think that is a very broad topic as well, that we don't want to just like quickly cover. So I think we will leave it for another time. And so let's say instructions that is basically not dealing with changes to the original scope of work that constitute to a variation. So we try to avoid talking about it here at the moment. Okay, but the notes are here today for you to read. So our power of SO to issue instructions are limited. It will be defined in the contract. Okay. So any instructions that is beyond the delegated authority may require prior approval from the client or the government, SO representative. Okay. So the government representatives, not SO, government representatives. So meaning that you have to go back to the client, to go back to the employer to ask for prior approval. Okay. If you don't follow it very closely, you just want to do whatever you want, then the consequences will come back and bite the apple. Okay, so there will be power authority. So in most Malaysian contracts, there will be delegated from power from the client, especially instructions related to execution of work, certification of payment, assessing and approving variation in EOT, calling for testing, inspection, and renewal. It depends on contract. It really depends on contract, because some contracts they are more private client involved, some is more government agency involved. So they do have a specific list of delegated powers from the client. Okay, granting CPC, these are all part of those power to actually give that kind of instructions in that sense. Okay, so these are some of the so if let's say these are some of the clauses here that involves SO issuing approvals, variations, instructions, and all that. Okay. And I think there will be instructions that we talk about that, if there's a instructions that's given on site and it's very urgent to do something, I think there is a category that you can actually allow oral, but all instructions must be in writing to be valid. Okay, it is important to make it in writing, and so you can actually follow up with the writing, especially if there's a critical situation, you're giving oral instructions. Then you must typically follow up with written instructions. That is you have to be very careful about that. So you can't just open your mouth and, give instructions and then like no responsibilities like that and, that's it, done already. So PWD forms and PEM form, they allow party to confirm such instructions within specific time frame, 7 to 14 days. So if you don't issue, then contractor has every right to not do it in this sense, So JKR also has a written first principle, so get it done, get it written first, get it right first before get the job done. Okay, so I think this is something that deals with instructions. So all instructions are to be in, especially dealing with variation, it has to be in writing. Okay, and the oral, yes, is issued because of critical situation, because of its urgent, but you have to come back with writing, okay? And that writing again has to be sent to it has to arrive at the other party's office. You cannot just write, and then that's it, you didn't send it out or the other party did not receive it. That is also the receiving and issuance and receiving issues that we have to be careful about as well. See? So like I said, power to issue instructions are limited to the contract, and you need to refer to the contract itself regarding the SO's power to do instructions, okay? And then similarly, I think there is a limitation of fiduciary role. So SO is acting on behalf of the client. So you must perform the duty fairly. I think it's something that some the over engineers, especially the older engineers, are very clear about that. And then do your job fairly. So but Malaysian law recognizes that SO actually have dual responsibilities. You must be a faithful agent. In VAM code of conduct, you must be a faithful agent to the client, but you are also an independent person. As an engineer, you must act impartially and faithfully so that you don't abuse your power, especially when it comes to withholding certification, issuing instructions. This is typical areas that SO can be hanky-panky about. I think I'm pretty sure we've faced many situations with TMNs. You may not be one of them, but there will be the individuals or certain companies that they tend to do this sort of things, you see. So where SO exceeds the authority or acts outside the contract terms, okay, client may lawfully dispute payment, and although contractor may seek redress under contractual dispute mechanism, okay. So it could lead up to bigger problems, if you don't read the instructions bit carefully. So we put power authority, the power to give instructions. So what thing you can give and what thing you must ask for prior approval. Okay, so I think these are what is covered here in the quality sections. There are some related clauses in various different forms, okay, on what we've mentioned about, inspections and all that. This is different contract, different practice. So this is some samples of clauses now. But again, we prefer you to read your own read your own samples, read your own contract before you execute. So again, reminder, contract and practical QMS, quality management systems, they complement one another. They should complement one another to make sure that the work is carried out in conformance to the standard, is conformance to the required design, and is actually done accordingly, so that what we deliver to the client and the end user as an engineer is actually good, is actually reasonably safe and well done, in that sense, meeting all the quality requirements. Okay, so I think that's all we have for quality. I'm actually speeding up a little bit for everything. So yeah.